Intellectual property creation and management for emerging growth technology companies. Copyright basics, infringement. This presentation is brought to you by the IP attorneys and professionals at Hulsey Intellectual Property Lawyers through the Hulsey Intellectual Property Technology and Invention Monitor website. Hulsey Intellectual Property Lawyers, IP professionals for entrepreneurship's new golden age. This presentation is part of the Technology and Invention Monitor website's Legal and Business Issues and Instructions resource. Intellectual property creation and management for emerging growth technology companies. Copyright basics, infringement. Let's begin the presentation.
Let's focus now on infringement issues. So in dealing with infringement, once infringement occurs, we've got a couple of options that are available. First is to send a cease and desist letter if someone's infringing our copyrights, to file a complaint in federal court for injunctive relief or damages to stop it and be compensated for it. And appropriate letters send a takedown letter, which is making them stop the use, take it off the internet if they're doing whatever, but just getting them to stop. The copyright infringement occurs when someone else copies your work. That's what cause you to do these types of things relative to copyright infringement. You have to make sure that you own the copyright registration. If you don't, boy, I'll tell you, it's going to be a mess, particularly if you've made a fraudulent filing as to the ownership of copyrights. I've seen that happen. It's not a pretty picture. It's not something that you want to be participating in, so that you need to know whether or not there is, in fact, copyright infringement. The cease and desist letter is, in fact, the next action to take once you've made that determination, and then again filing for injunctive relief. What are the damages? The damages available in a copyright are actual statutory and attorney's fees, actual damages. You don't have to have filed for the copyright registration before the infringement occurs if you can show actual damages. And that includes gross revenues that are directly attributable or indirectly attributable, but for attributable to the infringing act. If you can show loss of profits for that, then those damages, those are the actual damages that can be shown. But also there are statutory damages, and we'll touch on what those damages are, and then attorney's fees and costs relating to the enforcement of the action. But once again, you have to have had, for published works, 3 months after, within 3 months after the publication of the work, you have to have filed your copyright registration, or you have to have filed before the infringement occurs. So if you file either before 3 months expires for published works or before the infringement occurs, if either one of those take place before your registration application, you cannot receive attorney's fees and costs. The registration application has to have gone in before those two things occur. So in the infringement action, clearly one of the first things you want to do is talk to a copyright attorney to determine whether or not an infringement action is necessary or whether you are in fact infringing. And some of the defenses that are available are invalid copyright, it's not properly subject matter, not copyright subject matter, or that the application was filed fraudulently, or other invalid copyright. Latches, the copyright infringement happened a long time ago, and as a result, the person who's pursuing rights against you doesn't have the right to do so. Statute of limitations, it's statutory. It's what's stated in the copyright statute as to your time limit, and that's 3 years. The fair use, it's within the fair use doctrine. There's independent creation. You can create something. This is different from the patent statute. If you can show that you independently created a work that even is substantially similar to a copyrighted work and you never saw, you did not have access to the original work, then even though there may be substantial similarity between the copyrighted work and your work, if you can show that you never saw it, then you can state and prove independent creation And that independent creation will avoid the successful copyright infringement action against you. Copyright misuse, the misuse of the copyright statute that's in violation of certain doctrines, court-established doctrines as to copyright misuse. Unclean hands, which means that the person that's asserting copyright infringement against you can be held if he or if that company's done bad things relative to you. Their ability, a court may limit their ability to pursue their action against you. Waiver, in other words, they may have told you that it's all right to infringe the copyrights. First sale doctrine means that the copyrighted work has already been sold, and the copyright has expired. Once a sale occurs and the copyright owner has extinguished its copyrights by being compensated for the sale of the copyright, not the CD, because with the CD you don't get the copyrights, you get the copy. There's no conveyance. But once that copyright has been transferred or sold, the original owner can't come after you. He's extinguished or he's spent his copyright rights. And then parody is a doctrine where you're poking fun at a copyrighted work and that you're not copying it. And there's all kinds of litigation, all kinds of doctrines that relate to whether something is or is not a parody, and therefore is or is not a copy. But a parody is an authorized defense for a copyright infringement cause of action. So remedies. Remedies in copyright infringement are statutory damages per the copyright statute, Title 17, up to $150,000 for a timely registered infringement work for each infringement. On the internet, if there's been a timely infringement and timely registration, and you can show that for every infringement that's taken place, you have the ability, each copy that's been made, you have the ability to show the basis for statutory damages. Actual damages suffered and profits of the infringer that are attributable to the infringement. This is causing damage has been caused to you as a function of the illegal copying of your copyrighted work is one of the other forms of remedies. And then further, attorney's fees if the application for registration was filed, again, before 3 months after the publication and before the infringement occurred. So now, with this sort of, how do you know if someone has infringed your copyrights? Well, the accepted tests, there have been tests throughout the years, but the most widely used test, when there is not identical similarity, identical copying between the allegedly infringed work and the original copyrighted work. And again, this can happen if you have an older registration and what is copied is a later version, which is not identical to the original registration. This test for infringement is a 3-part test, and it's called abstraction, filtration, and comparison. Abstraction, filtration, and comparison. And the test involves abstraction, raising up what is the copyrighted work, what is the original creation that the copyright laws protect. Filtration, what is the copyright, what in the copyrighted work is protectable. So I filter out from the work that which is protectable as being statutory copyright subject matter. And then after that, abstraction as to what is the copyrighted work, and then further, what of this work is protectable. Then the comparison occurs between the accused work and the protectable part of the copyrighted work, and if there is substantial similarity between the two, then copyright infringement occurs if there's been access. Access and substantial similarity as proven by the abstraction, filtration, and comparison test. So let's look at this. I have a deposited copy of a registered work, and so then I have the abstraction here. You know, the inventory, what's there? Word choices, sentence choices, paragraph choices, chapter choices, orders, and the theme. The filtration, okay, there are quotes from others, not original, scene affair. It's these things that are factual in nature. As a result, they're not protectable. Not protectable subject matter. So now I have the filtration, and then I have the registered work that's been filtered from, and then the accused work. And then this is the point at which I determine the existence of substantial similarity. So let's use the example of a textbook. I have the original here and the copy. And the levels of abstraction are the plot, the scenes, the elements, the chronology, protectable work, characters, names, traits, relationships, possibly, or the dialogue that takes place between the characters. Maybe a novel also would be another example of a type of process. But then I have these different levels in which the abstraction, filtration, and comparison. So let's look at here at these for the plot. Here, that which is in the large part, there is going to be larger, the scenes, the chronology, and all, more originality.